Yes, good morning to everybody. So welcome to our today class, a special class from 7:10 to 8 morning AM. The same class, the next class is from 3:10 to 4 PM. The third class is, as usual, from 7:10 to 8 because I want to compensate it rather than going fast. That's my intention. So now let me share the, yes, where is this gone? Yeah, now could you see that what I pasted on the screen?
Yes, sir, I can see, sir.
Yes, can you read what is the meaning of it? Yes.
Work in progress.
Good.
Men are at work. Something, sir. Something like that.
Then only that much. There is a manhole also.
Yes, sir.
But why you
Yes,
are
sir. There
not
is a manhole.
you are not saying that there is a manhole? Hmm? So it is a caution they are showing over there for the disclaimer class. The caution is for the disclaimer class. Is it or not? Okay, let us come to our point because yesterday that we are
Yes, sir.
discussing this case law, Cutler versus McFile case law. This is about the release. It is about the release case law. So it is one of the mode where a tort can be discharged. So the defendant wrote a defamatory letter containing the contents against the plaintiff and he sent to the villager magazine and another copy to the officer in Pinner Association. So a person is reported something defamatory and he wrote to the villager magazine and the editor is published over there. So the plaintiff sued the editor of the magazine and the defendant. Defendant is the reporter because he sent the defamatory matter to the editor. So here the plaintiff sued the editor of the magazine and the defendant, both of them jointly and severally, they made it. So the editor of the magazine published the apology in the Villager magazine. The magazine name is the Villager, and the editor was acquitted from the charge of the defamation. So now the contention of the defendant is there. It is me who wrote that defamatory letter, and that was published in the Villager magazine. Now you have acquitted you said the release the editor, but the same cause of action. So that the defendant contended that the release of the other joint tortfeasor, and who is the other joint tortfeasor here?
The plaintiff.
Editor is the joint tortfeasor, and the person who wrote is the defendant, the defamatory matter. So you release the joint tortfeasor editor. That means for the same cause of action that you release means the extinguishes the cause of action. So therefore, it is also extinguished the cause of action against the defendant, and he was released from the liability of the defamation. See, if you, in the joint tortfeasor, for the same cause of action, if you release one person, automatically the same cause of action, you cannot take any case against the other tortfeasor. Because if you release, you have to release the both of them. If you don't release them. But partially for the same cause of action, you release one person and you detain another person, it is not a formal release and it is not it's not taken into consideration. So that's my point. Is it clear?
Yes, sir.
Release means total release. Not one person tortfeasor released, another tortfeasor is detained. No. But waiver, it depends upon the discretion of a person. Because he is my wife's brother, so he waived it. But other person, he did not waive it. That is his discretion, that is. So now let us see the another judgment. The mode is extinction of the liability in the tort is judgment. So here judgment, generally people, they don't write the E here. So this is the style they use it in the judgment. So judgment in this method, the discharge of the tort happens by the judgment given by the court. If once the court gives the judgment on the matter, the tort gets discharged. No appeal for the same act of tort can be claimed for the same remedy in the court of law. If once the judgment would be given over there, if he once accepted, it's well and good. But regarding the certain matters are there, if you're not happy by the compensation which you received, especially in the land acquisition, then you can go to the High Court or the Supreme Court for the hike of your compensation. But here, If once the judgment is given for some cause of action in a particular matter, means that is a binding. So the concept of this method of discharge of tort is based on the legal maxim of res judicata. Of course, that you will study in the evidence, the res judicata means the matter is already once settled or decided by the competent court. If any cause of action decided previously by the court, the same cause of action should not be entertained by the court twice. Because same cause of action, same facts, if once decided, it decided forever. Again, for the same cause of action, again, the court will not waste the time because already decision is taken in the so-and-so case law that is the binding on each and everybody. Of course, if the district court is there, okay, it may be binding in that state only. But if it is the high court, it's a persuasive value for the other high courts. But in the same high court where the state is there, in the state high court, then all the subordinate courts will follow the decision of the state high court. And the persuasive for the other high courts. Is it clear?
Yes, sir.
So now let us see for the same, for the cause of action for the twice. This is regarding the judgment is concerned. Illustration is, read this illustration. Anyone can unmute and read this illustration.
If A gets the
If
remedy
A
against
gets
B
a
for
remedy against B,
Okay, only one can make it up.
if A gets the remedy against B for the accident committed by him previously by the judgment of the court, later he found that he needs to go through a further operation, he cannot claim another remedy for the same again in the court of law.
Because the same cause of action, once it is decided, see, once it is decided, again we need not to go. Suppose the Supreme Court has given that triple talaq is against the Constitution. Is it or not?
yes, sir.
Again, can somebody will go to the court, triple talaq is constitutional? It's already
No,
decided
sir.
by the Supreme Court. Is it or not?
Yes, sir.
So once it is decided over there for the same cause of action, again the decision will not be taken. So that is called judgment. Once is given, it is a res judicata. Means it's once decided, the same result will be holds good in other cases also. So let us see the Fitter versus Wheel case law. In this case, the plaintiff files a case against the defendant, demanding damages against the act of assault by the defendant, and finally he gets the remedy from the defendant as the court of law allows the remedy to him. And assault means causing the reasonable apprehension on the another person is called assault. Are you following me?
Yes, sir.
So, how the reasonable apprehension, I will show you. So, if anybody comes like this, you make that fellow who sees it now, jankutad, he will get feared like this. Have you observed? If suppose somebody comes like this, make it out. The other fellow to whom that he wants to give the punch, no, he will be like this. So
Yes,
he will get
Yes, sir.
apprehension. That is called apprehension. That is called assault. When somebody is going to give the punch, then that fellow will make a back, the head, automatic reflex system, get feared over there. That is an assault. So in one of the case law, the assault, a court has given the compensation. Means a remedy is given to him. Later, he discovered that he has to go through the number of surgeries, and he filed another petition against the defendant demanding the more remedy against the assault again in the court of law. Suppose in the assault, he got it. Assault actually is not a battery, but he needs some other surgeries for would be there. Some other operations should be given. Made it over there. Let us see what will happen. The court denied the petition and state that if once the court gives the judgment on the matter, no further appeal for the same for the tort can be filed in the court of law as the tort gets discharged. Only it is an assault. If anything goes, if you want to file it another way, it is a separate one. It is nowhere connected to this one. So, if for the same cause of action, again the judgment will not be given because already he got the compensation for the assault. For the other things, he is not going to get it. So that was the thing that actually happened over there. But it does. It has the exceptions. Suppose if you got injured over there, of course, for the injury you got the compensation. But because that injury has leads to the amputation of your leg, means your leg should be severed over there at that time. Okay, even the severance also comes because the same cause of action, the result has come out. So that is an exception to this one. If the petition was between the same party but is of different remedy, or the action taken in respect to the violation of another right, so another right violation is there, then one can file a separate petition. So that is the cause of action is different. Then the petition can be allowed at that instance. If you read this Bernstein versus Humphrey case law, you will understand what actually it says about the above one judgment. Okay, read this case law. Yeah, now you read it, Joshua. Yes.
Yes, sir. I'm ready. In this case, the plaintiff was a cab driver and already received compensation against the damage to his cab. Later discovered, due to the injury caused in the accident, he got a fracture in his hand. He has the right to apply for the remedy against the trespass to his body as well.
So here in this case, what happened? Plaintiff was a cab driver. You know, cab means that's a taxi like that. Okay? Because in the states we'll say cab, but here we'll say taxi. So he was a taxi driver, the cab driver, and already received a compensation against the damage to his cab. He already received the damages to his cab. Cab means to his car, the taxi. Later discovered due to the injury caused in the accident, he got a fracture in his hand. Because of the injury, later he found that because of the accident, he got a little fracture in his hand. He has a right to apply for the remedy against the trespass to his body as well. Because injury to the car is different and injury to the person is
Body is different.
Different.
So two cause of actions are there. Of course, accident, only one accident, but resulted the injury to the, means damage to the cab and injury to the person. Got fractured over there. So one is human being, another is inanimate thing. So there are two cause of actions would be there. When two separate remedy, injury is there. One injury to the car, another injury to the fracture, that is to the person. So there are two things are there. If the person who is liable for the act previously does the same act another time. So here he has the right to apply for the remedy against the trespass to his body. But the first one is trespass to the goods. Are you following me?
Yes, sir.
Yes, sir.
Trespass to the goods means goods are damaged. Trespass to person means assault or battery or fracture, kick or punch or any other thing. Let us see the illustration. If A commits a tort of trespass against B previously and held liable by the court of law. Previously he made the trespass and he was held liable. Okay, good. If he again commits the same crime against B and if A plea defends that the court cannot punish him for the same offense twice, the defense is not valid because this case was considered as a fresh one. Did you get me this example? See, one time he made the trespass. Okay, court has given the compensation to the plaintiff. The second time also he made the trespass. Can he say that, sir, court already gave me the punishment to me, then why again the punishment to me for giving the compensation to the plaintiff? Tell me. Can he ask so? Because it's a fresh trespass. A fresh trespass, second time trespass. Are you following me?
Yes, sir.
So for the second time trespass you made is there. A second offense is committed. Somebody's right is violated. For instance, if you say that you are giving a kiss to a girl, let us presume it. The first kiss, okay, the court say you touched her and hence it is an indecent activity, so you should be punished. So compensation is paid to the person who is the plaintiff. Okay. Second time again he kissed. First time already the court has given the punishment to me. Again, why they are going the punishment for the second one? The reason they said, you did the act second time. Are you following me?
Yes, sir.
When you did the act second time means you violated somebody's rights. Hence, again, second time punishment. If the third time also he did it, the court will say, this fellow will keep it, he will give the money and he will be free. Let him put in the prison for at least 6 months. Are you following me?
Yes, sir.
See, every time he is punished over there for giving the kiss and he paying the compensation and coming out. Second time he did the same thing, paying the compensation coming out. So it became a nuisance. Are you following me?
Yes, sir.
So
Yes,
that
sir.
means that better punishment, okay, compensation should be paid the victim or who got the case. But this fellow should be put it in beyond the bar. So that again he could not commit the
Same thing.
okay, suppose if we kiss the window sills, gate sills, yes,
No problem, sir.
there is no violation of any right. Are you following me?
Yes, sir.
Yeah, at the time that he will not be punished. Suppose you will kiss the wall. Okay?
Okay, sir.
Yeah, that is the thing. But acquiescence, here what is with the acquiescence, let us see. In this method, the tort gets discharged because of the incapacity of the plaintiff himself. That is, it has to, if he has no time to go to the court, no money to pay the court fee, or any other incapacity, when any person is entitled to enforce his right and he does not enforce the right for the long time, he makes the other party waived for his liability. See, if that fellow doesn't have the money and he is a poor person, he cannot fight it. On behalf of somebody will file a case. Yes?
No, sir.
If it is a public issue is concerned, okay, PIL. Suppose if the personal issue is concerned, land ఉన్నదండి వాళ్ళది ఏది ఫ్యామిలీ డిస్ప్యూట్ బ్రదర్స్ సిస్టర్స్ మధ్యలో. But this fellow is, the sister is very much a rich lady. And this fellow is a very poor man. Means he is not that much rich. And he cannot go to the court. The sister says, see, don't fight it, file the case in the court. Okay, I will give you this much amount to you. Okay, because now girl also having the equal share. Am I right?
Yes, sir.
So I will give the 50% to you, don't worry. No, I want only the land. I said, see, that land, we cannot construct it. Better you take the money. But no, I want the land only. I say, why do you want? If you go to the court also, okay, court will say, okay, give the land. But what do you do with that land? You cannot construct your own house. Even myself, I could not construct the own house. At that instance, the brother will listen it. Okay, you give me the whatever you want to give me, I will keep quiet. But his cousin brother says, Arey, Yakra, ante nikittanra, the gold ra. Can you file a case on behalf of this fellow?
No, sir.
Answer no.
Cannot.
Because his incapacity. His incapacity is a family issue. Okay, either he or his son or daughter, the brother's daughter, children. Okay, they can. Because they are the legal heirs. Are you following me? My father doesn't have the money. It doesn't mean that we don't have the money. Are you following me? So they can make it. This is called acquiescence. So if the incapacity would be there, then somebody will not come and raise it and I will file a case on behalf of you. No, because he said, better see, I will take the money, I will keep quiet. So he waived his liability. So if A is entitled to enforce his right against B, yes, he is having entitled because his brother can file a case against the sister. Are you following me? Of course, sister also
Yes,
did
sir.
not deny it. Sister wants to give to the brother 50-50. Okay. So if A is entitled to enforce his right against B, good. If A neglects to enforce his right for that long time, he is automatically waived B for his liability. That is called acquiescence. He is having the right, but he said, "Are ye poni right? He court chutte vardi rigala. Poni ne poni. Gamana adrishta intane unnadi, and our fate is like that. Okay, keep quiet." And he doesn't file it. That means he acquiescence. Means tort. Of course, here the right is there, but it will be extinguished because of the time factor. Liability, Limitation Act. So Limitation Act will come into the picture. So right will be there, but the remedy will be extinguished. Am I right?
Yes, sir.
ఇక్కడ ఇయ్యాలి ఓకే కానీ చచ్చిపోయిన తర్వాత అక్కడైతే జవాబు ఇవ్వాలి కదా. Is it or not?
Ante, sir. Yes,
So
sir.
that right is there, but the remedy will be extinguished because of the law of limitation. Number one, because of his money, he could not file it. Okay, fine, and he kept quiet. So that means he waived it. That is called acquiescence. So let us see one of the case law. Yes, read. Pratibha, you read. Read this case law.
The plaintiff was a tenant at will of the defendant, the landlord. The plaintiff did not contact the defendant, but an agent of the landlord. Landlord promised the plaintiff to renew the plaintiff's lease for a period of 60 years. The plaintiff started to construct a building and also sued the defendant for the renewal of 60 years lease. The plaintiff pleaded the doctrine of acquiescence from the defendant. It was held that the plaintiff has no right as he was a tenant at will, and the assurance given by an agent of the defendant could not bind the defendant.
Yes. So in this case law, what will happen? The plaintiff was a tenant. Means he he leased the house. At the will of the defendant. Because defendant agreed. Of course, either he produced the will. Here will means the intention of it, not that will nama. Will nama raskuntara and rent la?
No, sir.
No. Here will means at the discretion, means okay, like I would like to give this fellow as my tenant, the plaintiff. So here the plaintiff is the tenant and the defendant is the landlord. Are you following me?
Yes, sir.
Clearly written here, landlord.
Yes, sir.
So the plaintiff did not contact the defendant, but an agent of the landlord. So the plaintiff did not contact the defendant, but he contacted the agent of the landlord. Agent of the landlord. So promised the plaintiff to renew the plaintiff lease for a period of 60 years. So agent said that, okay, I will extend the lease period of the 60 years. Tenant. The plaintiff started to construct a building and also sued the defendant for the renewal of 60 years lease. The plaintiff pleaded the doctrine of extinction from the defendant. So here your agent told me for 60 years lease. So with that view, I am making the Pakka building a good construction which will be serve up to the 60 years, and because of your agent I am doing the things, then the plaintiff has sued the defendant, the landlord, for the renewal of the 60 years of the lease, and he also took the defense of the doctrine of acquiescence because your agent told me for the agent activity principal is held liable. So it was held that the plaintiff has no right as he was a tenant at will, and the assurance given by the agent of the defendant would not be bind the defendant. Sir, if villa matram, defendant is the will is there. If you want, he can continue it, but you have to approach to a defendant, but not through the agent, because it is not a matter of 60 years. Evadana lease 60 years ki istada andi illuను
No, sir.
ఎంత ఎన్ని సంవత్సరాలకి ఇస్తారండి?
అంటే 10 సంవత్సరాలు ఇస్తారు సార్.
నో, 11 months ఇంటి రెంటల్ అగ్రిమెంట్ ఉంటుంది. 11 months ఇస్తాడు, 1 month నోటీస్ అంటాడు. బిజినెస్ ఉన్నది అనుకోండి, ఓకే, 2 years, 3 years, 5 years, బట్ అందులో కండిషన్ పెడతాడు ఏమని, ఎవ్రీ ఇయర్ 10% ఇంక్రీజ్ వుడ్ బి దేర్ ఫర్ ద రెంట్. కానీ లాంగ్ లీజ్ ఉంటాయి అనుకోండి, ఏది ఇంతకుముందు సింగపూర్ ఇచ్చింది కదా లీజ్కి సంథింగ్, సో దట్ లీజ్ పీరియడ్ ఈజ్ ఓవర్, దెన్ ఇట్ బికమ్స్ ఇండిపెండెంట్ ఆర్ సంథింగ్ లైక్ దట్. సో ఫర్ అ లాంగ్ థింగ్ ఈజ్ దేర్, లైక్ ఎస్ దట్ వీ కెన్ బి సెడ్ యాజ్ ఎ లీజ్ 100 years ఇస్తారు. సో దట్ ఈస్ ఓన్లీ ద స్టేట్ ప్రాపర్టీ దట్ పీపుల్ విల్ గివ్, ఆర్ ఏ association people only give, because the association will not die. Association will be continued. A society will be continued. But the people in the society may die. But another members will be elected. Are you following me?
Yes, sir.
Yeah, that is the thing. So here when you are giving it the will of the defendant, you cannot bind at that in the acquiescence radadi, because whenever such a thing would be there, you have to ask the అందుకోసం అంటారు కదా, లెట్ మీ హియర్ ఫ్రమ్ ద హార్స్ మౌత్ అంటారు. డిడ్ యూ గెట్ మై పాయింట్? అర్థమైందా నేను చెప్పింది?
నో సార్.
లెట్ మీ హియర్ ఫ్రమ్ ద హార్స్ మౌత్ అంటే అర్థం ఒరిజినల్ మనిషి చెప్పాలి నాకు. ఇప్పుడు మేనేజర్ అన్నాడు అనుకోండి, వాళ్ళ సూపరింటెండెంట్ వాళ్ళ ఎవడో కింద పనిచేసాడు చెప్పింది అనుకోండి, యూ డోంట్ ట్రస్ట్ ఇట్. లెట్ మీ హియర్ ఫ్రమ్ ద హార్స్ మౌత్ అంటే మేనేజర్ గారు చెప్తారే విన్నాం. అరే ఇవాళ బడి లేదురా అన్నాడు అనుకో, ఎవరు పిల్లలు అనుకోండి. సో లెట్ మీ హియర్ ఫ్రమ్ ద టీచర్ ఆర్ లెట్ మీ హియర్ ఫ్రమ్ ద హార్స్ మౌత్ అంటే హెడ్ మాస్టర్. హెడ్ మాస్టర్ చెప్పింది అనుకోండి బైండింగ్ అది, కనీసం టీచర్ చెప్పింది అనుకోండి బైండింగ్ అది, మీ క్లాస్ లీడర్ చెప్పింది అనుకో బైండింగ్ అవుతుంది అండి అది?
నో సార్.
నో, బికాజ్ లెట్ మీ హియర్ ఫ్రమ్ ద హార్స్ మౌత్ అంటారు అంటే ఒరిజినల్ మనిషి నుండికి విందాం, హూ హెస్ డిక్లేర్ ద హాలిడే. సో దట్ ఈస్ కాల్డ్ లెట్ మీ హియర్ ఫ్రమ్ ద హార్స్ మౌత్. అంటే ఇక్కడ లెట్ ద tenant will hear from the defendant who is the landlord, not from the agent. Okay?
Okay.
Okay.
Okay, sir.
So that is actually the thing here.
Yes,
So
sir.
it was held, yeah, it was held that the plaintiff has no right. As who is the plaintiff? In this case, who is the plaintiff?
The tenant.
Tenant is the plaintiff. And the tenant at a will of whom? Defendant. And the assurance given by assurance ever icharu?
Agent of the landlord.
Agent of the landlord. The defendant could not bind the defendant because then such a thing would be there. One should, సార్ పిల్లనిస్తానన్నారు, ఓకే ఎవరన్నారా? చిన్నాయన అన్నాడు. ఎందుకు వాళ్ళ నాయన లేడా? ఉన్నాడు. మరి చిన్నాయన ఎందుకు చెప్పిండ్రా లెట్ మీ హియర్ ఫ్రమ్ ద హార్స్ మౌత్ అంటే ఎవరు?
తండ్రి.
వాళ్ళ ఓన్ తండ్రి ఉన్నప్పుడు చిన్నాయన ఇయ్యడం ఏంటండి? ఇఫ్ ద ఫాదర్ ఈజ్ సపోజ్ ఇన్సేన్ ఆర్ మెంటల్లీ రిటార్డెడ్ అండ్ ఈ కుడ్ నాట్ నో ఆర్ ఏజ్డ్ ఆర్ హీజ్ ఎ విక్టిమ్ ఆఫ్ యాక్సిడెంట్, ఓకే చిన్నాయన ఆర్ అదర్ పీపుల్ మామయ్య వాళ్ళందరూ కలిసి ఓకే దే విల్ మేక్ ఇట్ ఫిక్స్ ద మ్యారేజ్, బట్ హీఈస్ వెరీ మచ్ capable of it. But with the capable of it, do you agree with the Chinnayana words? Answer no.
నో.
No, sir.
దాన్ని ఏమంటారు? లెట్ మీ హియర్ ఫ్రమ్ ద హార్స్ మౌత్ అంటారు. సార్ వాళ్ళ నాయన హార్సా సార్? అది ఫ్రేజియాలజీ నాయన, అది సామెత, దీనికి ఒక ఉదాహరణ, అది మెటాఫర్ అన్నట్టు, అది ఒక విధంగా
Okay, sir.
ఫ్రేజియాలజీ అది. అరే వాడు చచ్చిపోయింది అంటాము, చచ్చిపోయిన దానికి ఏమనాలండి? హీ డైడ్ అంటాం, అంతేనా?
అంతే సార్.
ఆరు పరలోకానికి పోయినా ఉంటాం, అంతేనా?
అంతే సార్.
మరి ఇంగ్లీష్లో ఇంకొకటి అంటాం, కిక్డ్ ద బకెట్ అంటాం.
అవును సార్.
మరి ఎందుకంటాం కిక్డ్ ద బకెట్ అంటే? వాడు కిక్ చేసిండే
ఊరేసుకున్నప్పుడు-
అది ఫ్రేజ్.
ఊరేసుకునేటప్పుడు బకెట్
Yes,
bucket
kick the
కొంత
bucket
అంతేనా
means, yes. That
while
means,
he's hanging.
yeah, in the phraseology, he said that fellow is kicked the bucket today morning అని చెప్పేసి, అంటే వాడు చచ్చిపోయింది అన్నట్టు అర్థం. అది ఫ్రేజియాలజీ అన్నట్టు. అది కూడా లెట్ మీ హియర్ ఫ్రమ్ ద హార్స్ మౌత్ అంటే చెప్పినోడు హార్స్ కాదు అక్కడ, అది ఫ్రేజియాలజీ. ఓకే
Okay, sir.
Okay, it was held that the plaintiff has no right as he was a tenant at will and the assurance given by the agent of the defendant could not abide the defendant. Now the law of limitation is the last. So under this method, the tort get dismissed due to the limitation. Limitation period untadandi. Law of contract limitation period entandi?
3 years.
3 years.
No, 6 years. అదే గవర్నమెంట్ కాంట్రాక్ట్ ఉన్నదనుకోండి 50 years ఉంటుంది.
Okay.
సపోజ్ యాక్సిడెంట్ అయిందనుకోండి, యాక్సిడెంట్ ఎన్ని రోజులు బట్టి మనం ఫైల్ చేయాలి కేసు?
Within 6 months, sir.
జనరల్లీ డిపెండ్స్ అపాన్ ద కేస్. జనరల్లీ 3 months, స్టార్ట్లో మాత్రం 3 months బిఫోర్ క్లెయిమ్ చేయాలి, 3 months.
Okay.
సరే మర్డర్ అయింది అనుకోండి, దానికి లిమిటేషన్ పీరియడ్ ఉంటుందా అండి?
Yes, sir. ఉంటుంది అనుకుంటా సార్.
24 hours.
బికాజ్ ఎప్పుడైనా మర్డర్ అప్పుడు ఆన్ ద స్పాట్ డెసిషన్ ఉంటుంది, ఎందుకంటే ద కంప్లైంట్ షుడ్ బి గివెన్ టు ద పోలీస్ స్టేషన్.
Police station.
నోబడి విల్ కీప్ క్వైట్. మర్డర్ అయిన తర్వాత సంవత్సరం తర్వాత ఇస్తామండి పోలీస్ స్టేషన్కి?
No, sir.
అసలు మర్డర్ అయింది అనుకోండి, ఈవెన్ పోలీస్ విల్ కమ్ టు యువర్ హౌస్. ఆర్ యు ఫాలోయింగ్ మీ? వాసన పడతాయండి, మర్డర్ వాసన ఎందుకు వస్తారు పోలీసు వాళ్ళు? కన్సోల్ చేయడానికి అండి.
Yes, sir.
The motto behind is different, but anyway they are coming and register the case, no doubt. So now the question comes over there. Some places the limitation period is there, and when you cross it, your right will be there, no doubt, but your remedy will be extinguished. Example అడుగుతారు క్వశ్చన్ ఇది, ప్లీజ్ అనలైజ్ ద స్టేట్మెంట్ ఆర్ ప్రపోజిషన్. ఏమని? law of limitation will extinguish the remedy but not the right. Discuss with the decided cases. అప్పుడు రాయాలన్నట్టు. ఓన్లీ రెమెడీ అది ఎక్స్టింగ్విష్ అవుతుంది, రైట్ మాత్రం మిగిలే ఉంటుంది. ఏ రైట్ ఈజ్ రైట్ ఎప్పుడైనా కానీ టిల్ ద డెత్. ఓకే.
Yes, sir.
ఎనర్జీ ఉన్నదనుకోండి, ఎనర్జీ ఓన్లీ ట్రాన్స్ఫార్మ్డ్ ఫ్రమ్ వన్ షేప్ టు అనదర్ షేప్, బట్ ఎనర్జీ విల్ నాట్ డై.
Yes, sir.
మెకానికల్ ఎనర్జీ నుండి ఎలక్ట్రికల్ ఎనర్జీ అవుతుంది, ఎలక్ట్రికల్ ఎనర్జీ నుండి మరి వాటర్ ఎనర్జీ అవుతుంది, వాటర్ నుండి దే చేంజ్ దట్ ఓన్లీ షేప్స్, బట్ ఎనర్జీ విల్ నాట్.
Law of conservation of energy, sir.
Yes, yes. So that is the same thing. The limitation set is 3 years for after the time limit gets over, no person can enforce his right. In case of false imprisonment and tort law, false imprisonment or libel, defamation, a limit to file a case is 3 years. Any defamation gaaniyandi, tort law gaaniyandi, false imprisonment gaani 3 years. After the limitation gets over, no person can enforce his or her right. So illustration, yes, read. Joshua, you read the illustration.
If a tort of trespass to the property has been committed by B against A, if A fails to apply against it within 3 years in the court of law, then he cannot apply as he lost his right to apply due to limitation.
Yes. So here, if a tort or trespass to the property has been committed by B against A, the trespasser is here B.
B.
The property owner is
A.
A. If A fails to apply against within 3 years in the court of law, then he cannot apply as he has lost his right to apply due to limitation period. But only right to file he will be lost, but not right. Remedy is lost only. Is it clear?
Sir, then what we can do without having a remedy for our right, sir?
See, సార్ మీరు అప్పు తీసుకున్నారండి ఒక 10,000 కాడికెళ్ళి. సరే, దెర్ ఇస్ నో ప్రామిసరీ నోట్, దెర్ ఇస్ నో రైటింగ్, మాట మీద ఇచ్చేసాడు 10,000 మీకు. ఏది వెన్ యు ఆర్ నీడీ. లా ఆఫ్ కాంట్రాక్ట్లో ఏముంటుంది? ఆఫ్టర్ 6 years లేటర్ యూ కెనాట్ ఫైల్ ఇయర్ కేస్. 6 years అయిపోయింది. అరే ఏమరా బాబు ఇస్తానండి, ఏరా బాబు ఇస్తానయ్యా, ఇట్లా 6 సంవత్సరాలు అయిందండి. అరే నువ్వు ఇక్కడ ఇవ్వకపోయినా అక్కడ జాబ్ చెప్పుకోవాలి కదరా అంటాడు. రైట్ ఉన్నది ఆపోయిందా? రైట్ ఉన్నది, కానీ నువ్వు ఇవ్వలేదు. ఎందుకంటే నువ్వు 6 సంవత్సరాల నుండి ఏం చెప్తాను? 6 సంవత్సరాలు అయ్యే వరకు ఇస్తా, రేపిత్తా, మాపిత్తా, రేపిత్తా, మాపిత్తా అని గుంజుకొచ్చినావు. ఎందుకంటే నువ్వు లా ఆఫ్ లిమిటేషన్ చదివినావు కాబట్టి. 6 సంవత్సరాలు అయిపోయిందిరా బాబు, నువ్వు చదువు నా మీద రుద్దుతాను, కానీ నీ ఆత్మ నిన్ను శాపిస్తూ ఉంటుంది. యువర్ ఇన్నర్ సోల్ డెఫినెట్లీ విల్ టార్చర్ యూ అండ్ యూ కెనాట్ హ్యావ్ ఎ పీస్ఫుల్ లైఫ్. ఆర్ యూ ఫాలోయింగ్ మీ?
ఎస్ సార్.
అది అంటారు దాన్ని. అరే నా రైట్ పోతే పోయారా, నా రెమెడీ పోయింది కానీ నా రైట్ అయితే ఉన్నదిరా బాబు. బికాజ్ ఎవ్రీబడి నోస్ దట్ ఫెలో ఈస్ గివెన్ ఓన్లీ ఆన్ ద మియర్లీ ఓరల్ బేసిస్ మీద ఇచ్చాడు. అది అంటారు అన్నట్టు. అరే నా ఉసురు బోధరా అంటారు చూడండి. ఇఫ్ ఎనీబడి
yes,
టార్చర్
sir.
యూ. సో దట్ ఉసురు తీసుకోవద్దండి ఎవరిదైనా కానీ. బికాజ్ ఇన్ ద మైథాలజీ ఆల్సో దేర్, ఇన్ ద బుక్ ఆల్సో దేర్, డోంట్ టేక్ ద కర్స్ ఆఫ్ ఎనీబడి. అండ్ ఎస్పెషల్లీ మనం అంటారు కదా పక్కల కర్సు తీసుకోవద్దని. ఆడిబిడ్డ ఏమంటారండి తెలుగులో?
ఆడపిల్ల ఉసురు.
ఆడబిడ్డ ఉసురు తీసుకోవద్దు అంటారు.
Answer.
Yes, that is, it is true. So now let us see the conclusion. A tort is an act or conduct that is a twisted, okay, crooked. But tort is derived from the which language?
Latin, sir.
No. French.
French. Sorry, sir. Totem.
So it means the violation of the legal right of a person by the act of the other person. Yes, it's a violation would be there by the other person towards another person. That is the breach of a legal right of the other person. But the right of action of the party can become a discharge in certain condition like the death of any of the property. Suppose in the case of it is there, automatically tort will be discharged by the 7 modes. What are they?
Death of the person, by waiver, accord and satisfaction, release, judgment, acquiescence, law of limitations.
మొత్తం 7 అయినాయండి.
Yes, sir.
ఓకే, అందులో వేవర్ వచ్చిందా?
వచ్చింది సార్.
Very good. So in the death of any party by waiver, by accord and satisfaction రాలే అక్కడ.
Okay,
accord and satisfaction రాలేదు అక్కడ. Okay.
Yes, sir.
Yes. Accord and satisfaction by release or by the judgment of the court of law and the limitation, though above method the tort becomes a discharge and no remedy will lie for tort. There will not be any remedy lie for the tort because it will be extinguished. Now let us see the one of the solved question in the function of liability. Read. Pratibha, read. Yes.
Explain judgment as a basis of extinction of liability.
Okay.
If the matter is decided conclusively by the authoritative court, then for the same cause of action among the same parties, the matter cannot be agitated again and further, or fresh suit is stopped. This principle relies on the maxim of res judicata. U/S 11
Under
of
section
under section 11 of okay sir under section 11 of civil procedure. Forever 1908 means things once thought about cannot be regulated. More than one action does not lie on the same line of action. The doctrine of res judicata rests upon the principle that one should not be punished twice for the same work, and there should be the conclusion of litigation. It also
Yes.
prevents a new investigation for the same cause, for the same case. A person cannot be harassed again and again in various proceedings for the same cause of action.
Because the cause of action is the same, only one cause of action. But he should not be twice punished. అందుకోసమే ఆర్టికల్ మన దగ్గర ఉన్నది ఆర్టికల్ 21 సబ్ ఆర్టికల్ 2 డబుల్ జియోపాడీ అంటారు. Means
Yes,
for the
sir, double
same
jeopardy.
offense one should not be punished twice. మనం we read the case law, one case law చెప్పండి, డబుల్ జియోపాడీ కేసులో చెప్పండి, ఫేమస్ కేస్ లా we discussed in the class.
Pass on, sir.
Mohammed Hussain versus State of Bombay. Because that fellow brought from Saudi Arabia a lot of gold, and the customs authority seized the gold and penalized him. Again, he will be punished under the CAFEPOSA, Conservation of Foreign Smuggling Activities Act. Conservation of the Foreign Goods Smuggling Activities Act. He was booked under it and he was prosecuted. Maqbul Hussain already told, sir, I was prosecuted already by the Sea Custom Authority. Then I paid the fine also there. My goods are, my gold is also seized. Of course, I pay the penalty and they released it. Again, for the same cause of action, you are prosecuting me under this act. Then the court has given the clarity. See, the sea customs or the custom officers, who they did it, it is not a prosecution. It is only the penalty. And penalty is not the prosecution. But you brought the gold because the limitation is there. You are not supposed to bring more than that. So you brought more than that and you did not reveal also. You did not reveal, yes, I brought. If you reveal it, okay, you pay the customs for that one, then you take it. But you did not reveal it also. Hence, a prosecution is there. So, customs authority is not the prosecution, but under the act it is a prosecution, and hence both are different. So, it is not a double jeopardy. So, that is the case law. We will study in the Constitution. I don't know whether Constitution up to the Article 21 we might have come or not Article. Is it not Article 21? No. Article 21 is there. Article 22. No, Article 20. You cannot be mistaken. Because 21 is a liberty, no? So, that was the case.
Right to life.
Right to life, Adi. So, I will give you the double jeopardy. Article 20, sub-article 2. That is the actual double jeopardy. Double jeopardy. Article 20, sub-article 2. FA. Yeah, Article 20. And sub-article
2.
2. Article 20 of the Indian Constitution provides protection in respect of the conviction for the offence. The Article 20, sub-article 2 contains the rule against the double jeopardy, which says that no person shall be prosecuted or punished for the same offence more than once. The protection under Class 2 of the Article 20 of the Constitution of India. So that is called double jeopardy. The famous case law is Maqbul Hussain, double jeopardy example.
Versus State of Bombay.
That is a beautiful case law where it can be made. So that is the thing which I want to share with you. And he should not be punished. Inkoka example cheptanandi, then I will wind up. Late ga chinandi son. So వాళ్ళ అమ్మ చూసింది, అరే నువ్వు నీకు చెప్పిన కదా నేను, యు ఆర్ నాట్ సపోజ్ టు కమ్ లేట్. మీ క్లాస్ ఎప్పుడే పోతారా? 4 గంటలకు. ఇప్పుడు ఎంత అయిందిరా? 6 అయింది. 2 గంటలు ఏం చేసినారా? లేట్ ఎందుకు వచ్చింది? పనిష్మెంట్ ఇచ్చింది. ఏమని? 10 గుంజీలది, సిటప్స్. గుంజీలు ఏమనాలండి ఇంగ్లీష్లో? సిటప్స్ 10 చేసిండు. ఆ తర్వాత వాళ్ళ ఫాదర్కి తెలిసింది, లోపల ఉన్నాడు, అరే మళ్ళీ లేట్గా వచ్చినావరా? ఎస్, తీరా ఇక 15 గుంజీలది. డాడీ, అమ్మ ఆల్రెడీ పనిష్మెంట్ ఇచ్చింది, ఇది ఆర్టికల్ 20 క్లాస్ సబ్-ఆర్టికల్ 2 కాదా డాడీ అంటాడు. కాన్స్టిట్యూషన్ చదివింది అనుకోండి, డాడీ యు ఆర్ నాట్ ఫాలోయింగ్ ద ఆర్టికల్ 2 సబ్-ఆర్టికల్ 2, ప్లీజ్ రిఫర్ ద మక్బూల్ హుస్సేన్ వర్సెస్ స్టేట్ ఆఫ్ బాంబే కేసులో. రిఫరెన్స్ తో సహా చెప్తాడు అన్నట్టు. సపోజ్ వాళ్ళ ఫాదర్ అడ్వకేట్ ఉన్నాడు అనుకుందాం కాసేపటికి, and then he will refer that article 2 sub-article, article 20 sub-article
2.
Yeah, that he will use it. So same thing would be there. So with this I would like to wind up today class, and my next class is from 3:10 to 4 o'clock. If one person also present over there, I will teach in the same spirit as if I am teaching to the 100%, because that is there in my
పర్సనాలిటీ.
మంచిగా చెప్పండి. సైంటిఫిక్ టర్మినాలజీ చెప్పండి, మెడికల్ టర్మినాలజీ చెప్పండి.
ఇన్ యువర్
డిఎన్ఏ.
ఓకే సార్, డిఎన్ఏ.
ఓకే సార్.
దాన్ని మామూలుగా చెప్పాలంటే ఇన్స్టింక్ట్ అంటారు. మామూలుగా చెప్పాలంటే ఏమనాలా? ఇన్స్టింక్ట్. INSTINCT అంటే నా బ్లడ్ లోనే ఉన్నది అది అన్నట్టు. ఇన్స్టింక్ట్, దట్ ఫెలోస్ ఇన్స్టింక్ట్ వుడ్ బి దేర్, ఇట్ ఈస్ ఇన్ హిస్ బ్లడ్ అంటారు. So in another
Yes, sir.
terminology, we will say DNA, because I want to give the justice to my students. I want to see every students like a Professor Hussain, replica, salute, shared. That's my intention. So with this, in the next class, I am going to deal the trespass to persons. Trespass
Okay,
to
sir.
Okay. Person.
Persons.
What are the things come under the trespass to persons?
Assault, battery,
Assault, battery, false imprisonment.
okay.
కానీ దాంట్లో కోడి కూడా కవర్ అవుతుంది, నర్వస్ షాక్ కూడా కవర్ అవుతుంది. బికాస్
Okay, sir.
assault to the body, battery to the body, to the mind, నర్వస్ షాక్. మనకు ఫేమస్ కేసులా మనం చదివాము. చెప్పండి ఇప్పుడు, అరే మీ ఆయన 2 కాళ్ళు పోయినాయి, ఇప్పుడు హాస్పిటల్లో ఉన్నాడు, ఈ గోయింగ్ టు టేక్ ద ట్రీట్మెంట్ ఓవర్ దేర్ అని చెప్తాడు. అని బేహోష్ అయిపోతుంది, 2 రోజులు లేవదు, అన్కాన్షియస్ కోమాలో వెళ్ళిపోతుంది. ఎందుకంటే మ్యారేజ్ అయ్యి కొత్తగా అయింది. ఆ కేసులా చెప్పండి.
Broom
Should not
versus
make
Morgan.
You should not make a practical joke ఆ కేసులా.
Broom versus Morgan, sir.
Repeat.
Broom versus Morgan.
No.
Morrigan.
Wilkinson versus Downtown. కేసులో ఏమంటిది? విల్కిన్సన్ వర్సెస్ డౌన్ టౌన్ కేసులో అది. డోంట్ మేక్ ఏ ప్రాక్టికల్ జోక్. విల్కిన్సన్ వర్సెస్ డౌన్ టౌన్ కేస్. ఇది కేసులో, విల్కిన్సన్ వర్సెస్ డౌన్ టౌన్ కేసులో ఏమున్నదండి? కేసులో చదవండి.
Downtown made a joke to Mrs. Wilkinson that her husband, Thomas Wilkinson, had an accident in which both his legs were broken and that Wilkinson should go to the Elmer's pub where tea was lying to bring home. These statements were false, but Downtown intended them to believe as true by Wilkinson, who suffered a shock to her nervous system as a result. Wilkinson had no predisposition to nervous shock, and the shock which caused her weeks of suffering and incapacity was not a result of previous ill health. Wilkinson raised an action against Downtown for compensation for her illness and suffering due to the false representation made by Downtown.
So this is the method you have to remember. The case law, practical joke case law. If one party say, other party should say, sir, that is Wilkinson versus Downtown, sir, case law. That is the way we have to remember it. So again, you have to keep it, man. Downtown versus Wilkinson, atla cheppadu malli.
Okay, sir.
You have to remember the first party name, Wilkinson versus Downtown case law. Suppose if you don't know Downtown or Downtown or Tanna, తెలియదు అనుకోండి, Wilkinson's case law enough. In the Wilkinson case law, it is decided making a practical joke is amount to a nervous shock. It is a trespass to person, it comes under it. Because it is a trespass to the mind. Are you following me? So that's why we should say Downtown, DOWN, ton. Ton పెట్టుకొని Downtown. Suppose if you don't remember it, at least you can write Wilkinson's case law. That may serve your purpose. So with this, I would like to wind up because the time is going to up at 8 o'clock. At any time, it is going to be stopped. If you want to ask anything, you can ask me. Yes. So if you happen to see here that I have shown you, yeah, it is the Indian tradition that in the beginning or the ending of any program that we will make the play of the national anthem. Now the national anthem will be. Jana Gana Mana Adhinayaka Jaya He Bharat Bhagya Vidhata Punjab Sindhu Gujarat
सारे जहां से अच्छा हिंदुस्तान हमारा। जय हिंद।
जय हिंद।